Sonia Ketting with the League of Women Voters of Larimer County. And we have Jeff Roberts here today with Colorado Freedom of Information Coalition. And in case you may not know, Larimer County has about 100 meetings a month, various agencies and parts of agencies. And we want to start showing up for more of them. So if you're interested to help us in that, I have this QR code anybody could snap. Not in this moment, I'll set it over on the table so you could capture it. And this is where you can show your interest and get a little more in touch. And it says volunteer observer, but there is actually a stipend for it to help motivate people. You know, it's a nice little supplement perhaps. And some of us might think it a good time or just a nice way to spend our time. So we're calling that right now, it's the Colorado Citizen Observer Pilot Project, and then we intend to go statewide. So we're testing Larimer County and then eventually across the West Slope, and there's 19 leagues across Colorado, so we could be doing a lot. And now we're just learning about how to do this. And the rules are Jeff's bailiwick, and thank you all for showing up. And he does these presentations a lot, so he's very adept if you want to pitch him questions while he tells us what he knows, and that'll be welcome. Thanks, everyone.
I'm passing a sign-up sheet around for everybody who's here, so we can get back in touch with you.
Could we have a show of hands of anyone who's not a member of League of Women Voters? Okay. Okay, good, thank you.
Hi, everybody. My name is Jeff Roberts. I'm the Executive Director of the Colorado Freedom of Information Coalition. If you haven't heard of CFOIC, it is a 501c3 nonprofit, nonpartisan. Its mission is to educate Coloradans, and we also focus on the journalism community in particular in our state about their rights under the open government laws. So the open meetings law, which I know you guys are very interested in, the public records laws, court access rules, criminal justice records, things like that. We also do some advocacy for government transparency in Colorado, and we work with organizations like the League or the Press Association, the Broadcasters Association, sometimes to make the laws better. And we always have something going in the legislature as well. So I've been doing this job for about 9.5 years. CFOIC has been around since 1987. The League of Women Voters helped found this organization way back when. It was a founding member of it. For many years, it was just an all-volunteer organization. I was hired to turn it into something that's an everyday resource for Coloradans. And a lot of what I do is, there's stuff to do every single day. My background is journalism. I was a reporter and editor at the Denver Post for 23 years. So been connected to the journalism community in Colorado since 1984. Our website that's what's up on the screen here, is coloradofoic.org. And I update this almost every day. I write a blog about open government issues. You'll see the latest thing that I wrote about a Court of Appeals ruling. I also aggregate stories from around the state about open government issues. And there's a lot of resources on this website. So we're very, very proud of our guide to the sunshine laws. So this is something we used to publish just in a booklet form. And a year ago, we put this online. I completely rewrote the thing. I put it online, and it is searchable by topic here over on the right side. And it links to the statute, it links to case law. What's great about having it online is that I can update it. So a court of appeals or Colorado Supreme Court ruling comes out that's relevant to open records, open meetings, and I update the guide. The legislature passes a new law, and I update the guide. So it's there, it's free. It's for anybody to use. We want people to use it. We want people to know what their rights are under these laws, yeah.
So is it downloadable, or do you recommend not doing that? Because
There's
you
not
get-
really a way to download it. I wouldn't, try to, I mean, it's just there on
And
existing.
it's most accurate.
Yes, it's there online, that's, I don't have a PDF version of it or anything like that. It is there as a sort of a living document that I will change when needed. It also works on your phone. So please check out our website when you get a chance. You can sign up for our newsletter if you'd like. If there is a sign-up sheet going around, you can put your email address on there if you're interested in getting our newsletter, and I can put you on there. But there's a way to sign up online too. So I'm going to talk today about these laws and a little bit about how to use them. Come on. There it is. Okay, good, thank you. Thank you for working. Things don't always work like they're supposed to. And once again, everything I'm going to talk about today is in that guide. So if there's something that you didn't get the first time around, then it's in there. You can always email me with questions. Please ask me questions as I'm talking now, if something that you want to follow up on something. So in Colorado and nationwide, we have these open government laws. You might be familiar with the federal FOIA, Freedom of Information Act. I don't deal so much with that because there's so much to do on a state and local basis. So in Colorado, we have two open records laws, the Colorado Open Records Act, the CORA. We have a separate statute that deals with criminal justice records, so police records, records of the sheriff's department, the DAs. And then we also have rules regarding court records and access to the administrative records of the judicial branch. Those are not covered by CORA. And then we have the open meetings law. So the open meetings law is part of the Colorado Sunshine Law, which was passed by the voters of Colorado exactly 50 years ago. So 50 years ago this November, Coloradans decided they wanted a more robust open meetings law. The law also had some stuff in there about lobbyist disclosure and disclosures for elected officials too. I wrote a blog about this, which you can find on our website, that I published in October leading up to about around the time of the election when it was passed. One of the things that the Sunshine Law did, because it opened up lobbyist disclosures of Denver Post reporter back in 1972, who is now in his 80s and is on my board, Fred Brown. That name might be familiar to you. He dug through all the lobbyist disclosures and put in a story that the Beer Distributors Association was spending $140 a month on beer for the state capitol press room. So that ended that. And as you'll read in that blog, Fred said he wasn't very popular among his colleagues at the State House Press Corps for a while. He's the greatest guy in the world, though. And it needed to end. That is, not the way we operate. Well, so I get to the State House Bureau for the Denver Post in the fall of 1985, 13 years later. That's when I started there. And I'm given this old roll-top desk to use, and in the drawers of the roll-top desk were Coors bottle openers, which was a remnant of that time when they used to just, So that's part of what the Sunshine Law did. The Open Meetings Law is really the thing that we'll focus on today and that is really relevant to keeping government open. It originally just focused on the legislature, and then it was expanded to local governments as well. And I'm going to keep drinking as I'm doing this because I get really dry. So just a moment about why all this is important. I think you already know the answer to this question. I do a lot of these talks for college students, especially college journalism students, and I really try to emphasize why these laws are so important and necessary. But the Colorado Supreme Court really summed it up in a 1983 ruling that I think it just says it really well, that for a self-governing people to make our democracy work, you need to know about the activities of government to vote intelligently in elections. That's what the League is all about. And also to hold people in government accountable. That's what these laws really, that's the purpose of these laws. So I'm going to start with the open meetings law because I know that's what you're most interested in. It begins with a very, very powerful statement. It's declared to be the policy of the state that the formation of public policy is public business and may not be conducted in secret. That's what it's all about. That's what the voters of Colorado said they wanted in 1972. And so it refers to not just, it governs not just meetings held in person, so a meeting of the Fort Collins City Council or the school board, whatever, but when they might meet electronically, like a lot of meetings happened on Zoom during the pandemic, maybe they still are, but it also pertains to them possibly meeting by email, by text message, by phone, by some other form of communication. And so there are rules about what constitutes a meeting that's open to the public. And so it could be, like I said, the city council, the county commission, the school board, but it's really any board that has, that is a public, part of a public body, that is a public body or has been given powers by a public body.
You
Yeah.
mentioned by text message, is that just prohibiting them from doing it, or is there some way for the public to access their?
Yeah, I'm gonna get into that in a second.
Okay.
Because it's a good question, and it came up with the Loveland City Council not all that long ago. So you've heard a little bit about that. So,
Here's a question here.
yeah,
Why is there a different number for local and state?
right. So, yes, it applies, yes, that's a good point. I probably shouldn't have gone past the slide without explaining that yet. So for a state public body, like the legislature or a committee of the legislature, it's 2 or more members whenever they discuss public business. For a local public body, it's 3 or more members or a quorum, whichever is fewer. The 2 or more members was in that original 1972 law that was passed by voters. It's still in effect. It is probably violated all the time by state legislators. But that's what is in the law. And, but the meeting itself has to pertain to the policy-making powers of that public body. So I get this question sometimes. 3 members of the county commission attended a meeting of a special district board or something else that's another public body. Should they have noticed that? Is that automatically open to the public if 3 members are at something else? The meeting itself, according to the high courts in Colorado, has to relate to their policy-making function. So if they're just getting a briefing from the sheriff about some crime that happened, it may not relate to that. but almost all of their meetings will relate to that. And so you can, occasionally we get some question about that. 2 members of the county commission showed up at some event that is otherwise not open to the public, should it have been open to the public. Did you have a question?
Yes, a few weeks ago in Loveland, we got a strange notice that after council meetings, 3 or more counselors may be meeting at one of the following restaurants or bars.
Okay, so were they doing that to invite you to show up, or? So the issue there is they're allowed to do that. The 3 council members can go to a bar after a council meeting and they can talk about their kids, they can talk about the Broncos, they can talk about whatever. If 3 or more members of the council start talking about what they just did at the council meeting, and it's related to their policy-making function, that's supposed to be an open meeting. So,
But does it need to be more specific than that?
well, it's interesting
Or
that
do
they.
we have to have 10 people at various
Yeah,
bars?
I mean,
saying,
so,
"Oh, they showed
so
up
you
here."
you don't know that they're not violating that unless you're there, or if somebody tells you that they went off topic, that they started talking about public business. So, it's interesting that they told you they were gonna go there
Yeah, it was an
and do
announcement.
that.
Yeah.
I guess it shouldn't matter if they're not getting into any kind of public
Yeah.
business. So I don't know if they were basically telegraphing that they might be talking about public business by doing that. I guess the only way to know is to show up and listen in.
How much time, though, Jeff, do they have to, can they just say, oh, well, 3 of us are here right now, and so we're announcing the meeting, and
Well,
then,
for-
like, there's no,
For a local public body, there's, if there's a notice requirement. So, 24 hours ahead of time, if 3 or more members are gonna, be there. So that's, here's something about the, full and timely notice, with specific agenda information where possible. So that's considered a pretty flexible standard, what is meant by specific agenda information. That sometimes gets violated in a pretty blatant way, and I've got a good example of that coming up. But those meetings are supposed to be open. And as far as text messages and things like that, so the issue there, I believe there was a story in the Reporter Herald a few months ago. Loveland Council agrees to stop texting during the meeting, right?
playing video games.
Yeah. And the issue there is, they're having a council meeting. The public has the right to observe that meeting. That's what the open meetings law is about. So either in person or online, if they're texting one another about something related to the meeting, you can't observe that. So that's a violation of the open meetings law because it involves a discussion that you're not privy to.
Even if they're in council,
Exactly. And even if you could do an open records request for the texting exchange after the fact, the open meetings law is about your ability to observe the meeting as it's going on. So, be wary of that type of thing. The other time that happens, and I know this happens probably more than we ever know, is 3 or more members might start a texting chain. Not during the meeting, but anytime, or an email chain. And some of that is allowed if they're just doing sort of scheduling for the meeting, that type of thing. But if they start talking about public business, if they start talking about the issues that are going to be coming up before the council, that's a violation. So it doesn't get, don't get caught very often, but this happened several years ago with the Pueblo City Council. So a reporter for the Pueblo Chieftain, there was a big controversy with I think a garbage contract or something like that. He is trying to figure out how to report on this story, and he does a Cora request for emails amongst several members of the city council in Pueblo. He finds some really interesting email exchanges, but also there's 3 members of the council on this exchange with a member of the county commission talking about this garbage contract. And that's a violation of the open meetings law because they were discussing the contract. And so he did a story not only about what was said behind the scenes, but the fact that it was an open meetings violation. There ended up being a recall against 2 of the 3, and I think 2 of them ended up resigning over this. Yeah,
What are the penalties and the remedies
yeah.
when this happens?
I'm gonna get into that. So, minutes are also a requirement, but only for certain kinds of meetings. So if they're going to take action, or there's a possibility that they might take action, then they have to take minutes. Open meetings should be recorded. And then back to that agenda or the notice. So this is a really blatant violation that actually ended up in court not too long ago. The Woodland Park School Board, controversial issue for them was a memorandum of understanding with a charter school. It was a controversial charter school. Some people really wanted it, some people didn't want it. The board put it on the agenda under board housekeeping. That was all that was on the agenda, were the words board housekeeping. They ended up talking about this very controversial issue, and somebody sued. And so it doesn't happen that there's lawsuits like this all that often, but somebody was pretty mad. And the judge eventually ordered the school district to be more forthright with how they announce these things. But then they allowed them to, the attorney who represented the plaintiff ended up not getting his attorney's fees in this case because the judge allowed the school board to quote, cure the violation at the next meeting, which was really, I don't know. It was such a blatant violation, I think. You know, how's anybody supposed to know? The point of the notice requirement is for you, the public, to know what's gonna come up at the meeting. And if it just says board housekeeping, how do you know that it's actually a really important issue? Another thing that has ended up in court in Douglas County, and this is still in court, although there's been one ruling in the case, and this was pretty high profile. If you guys watch Next with Kyle Clark, he did a lot of stories about this, because they fired the majority of the school board fired the superintendent outside of public view. And that's something that needs to come up and to be decided in a public setting. So they did this in a sort of controversial way. They did it in a series of one-on-one meetings. So remember that the open meetings law for local public bodies is 3 or more members, or a quorum, whichever is fewer. I think this is a 7-member school board, so that would be 3 that would make a meeting. But what they did in this case is 2 of them met to discuss ousting the principal, and then relayed that to a 3rd and a 4th. And so eventually they had agreement among 4 to fire the superintendent. So they didn't do it all at once, but this is called a serial or a daisy chain meeting. And the judge has ordered in a preliminary injunction don't do this. This is a violation of the open meetings law. This case is still ongoing, and we'll see what happens with it. It could go to trial in January. So I'm watching it very closely. This is the first case in Colorado we have about these types of meetings and whether they're a violation of the open meetings law or not. If they're not a violation of the open meetings law, then boards could just do this all the time behind the public's back. And it really goes against what the open meetings law is all about. Yes?
Are you gonna get to somewhere in this about, going into executive session for personnel and evaluations and, land purchases?
Yeah.
I think but it seems it's getting bigger and bigger.
Yeah, I will get to that.
Okay.
Here is an explanation from our board president, Steve Zansberg. Steve is the main First Amendment media law lawyer in Colorado, and he's also the president of CFOIC's board. This is how he described the daisy chain meeting. He's representing the plaintiff in this case, who just won election to the legislature down in Douglas County. So it's basically, two members of a school board can meet and talk about whatever. It's not a meeting under the open meetings law. But once they start sharing how they feel about that topic with a third or a fourth, then it becomes a meeting under the open meetings law, or at least we think it does.
So I could say, what do you think about firing Joe to you? We're on the board.
Yeah,
And now I know where you stand, you're with me, and then I go to Sonia and I say, hey, what do you think about it? As long as I don't say what I know you think about it, then I'm cool.
that's essentially it. That's essentially it. I mean, if that's how you could read the law. And that happens a lot too. But in this case, I think they were, they all got together and that way, and then eventually they informed the superintendent without telling the three members of the school board in the minority that they were doing this. And they told the superintendent, we don't want you anymore. So they came to that conclusion that way. And I will get to the penalties and things like that. I will get to that. So secret ballots, this also just came up as an issue. And this is another thing that is in the law. A public body cannot use secret ballots to make decisions. And so the only thing they can use it for is to elect their leadership. So, a weak mayor form of government, the council elects the mayor, and they can decide on that with secret ballots. So this just came up, and you may have heard about this. We made a deal of it. KUNC Radio actually broke this story in October about the legislature using this secret ballot system to decide issues with fiscal notes. So issues that cost money. What are they going to prioritize? And so they're using this system called, and this is in the Democratic caucus. The Republicans have sort of played around with it, but the Democrats are in charge. They decided that this is a very efficient way to figure out how their caucus feels about issues that are going to cost something in the budget. It's called quadratic voting, and they've been doing this for like 3 years now. And KUNC did a deep dive into this, called me. What do we think about that? Well, there's two problems with it, two big problems. One is that the legislature itself outlawed the use of secret ballots to make decisions. That's in the law. I think it's been in there since 2013, maybe 2011. Way before that, in 1983, the Colorado Supreme Court ruled that caucus meetings have to be open to the public, legislative caucus meetings. So they're doing this all in secret. They're doing it by computer. And so we wrote a letter to the legislature, legislative leaders, saying, please don't do this anymore. They did not respond to that letter. I know that KUNC and some other reporters are going to keep on top of this to see if they continue to do this next session. We'll try to keep on top of it. But that is, seemed pretty blatant to us that the legislature itself is violating a Colorado Supreme Court ruling and the law that it itself passed about secret ballots. Executive sessions. So you asked about that. So that, lead into the Sunshine Law, the Open Meetings Law, that it's the policy of Colorado that the formation of public policy shall not be conducted in secret. There's some exceptions to that, and that's when they can close the door and go into executive session. And there are specific things that they can talk about behind closed doors. And that could be actually closing the physical door. If they're on Zoom, that's excluding the public on the Zoom, whatever. There's a very specific procedure for going into executive session, and this is another thing to sort of watch out for if you're going to be going to public meetings. They have to announce the particular matter to be discussed in as much detail as possible without ruining the point of going into executive session. So they need some topic specificity so that the public has some idea what they're going to be talking about behind closed doors. It also sets some guardrails for them internally that they know they're supposed to stay on topic. They're supposed to cite the provision in the Open Meetings Law that allows them to go into executive session, that authorizes it, and then they have to take a vote to do that. This gets violated a lot, I think. You'll hear that they just say under statute, blah, 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 we're gonna go into executive session now. And the people who are watching the meeting really don't have a clue what it's about. So they need to be more specific than that. There is a Court of Appeals ruling about this from a couple years ago about how specific they gotta at least tell you something about that in order to do that. And you can't make decisions in executive session. So this is another thing that we see where a board will come out of an executive session and immediately vote on something. And you're like, how did they come to that conclusion? They can discuss the particular topic, but they're not supposed to do a poll, they're not supposed to vote on something in executive session. They're not supposed to make a decision. Executive sessions are supposed to be electronically recorded, except for portions that are them getting advice from their attorney. And so this is another thing to watch out for, and it's another thing that can be frustrating because they can say, we're going into executive session to get advice from our attorney on this issue. And who knows what they're talking about in there. They could be talking about the whole issue instead of just limiting it to getting legal advice. And you don't know necessarily, you never know unless somebody comes out of there and talks about the executive session, or you are successful in getting a recording of that released. And there's only two ways that can be done. The public body itself has to vote to do it, or you take them to court. And you get a judge to listen to the recording in their chambers, and they decide. That doesn't happen very often. So if you ever, if you get very suspicious about that, you need some sort of reason to believe that they violated it. That's why it doesn't end up in court all that often. This is an issue right now with the Aurora City Council because they made a decision in executive session to not censure a fellow board member. And the reporter for the Aurora Sentinel is reporting about this, heard about this. The Aurora Sentinel has actually sued the city council about it. So what are the penalties and remedies and things like that? There is, there's not a ton of teeth. So these are some of the violations we've just talked about: making decisions in executive session, discussing public business, outside of public view by email or text message, using secret ballots, failing to provide the proper procedure, these serial or walking quorums we talked about, discussing a topic behind closed doors that's not authorized. You need to have some sort of, if you want to challenge that, the only real remedy is to go to court. There's no administrative way to get that reviewed in Colorado. Some states have something like that. In Colorado, you would have to go to court. And a judge could release an executive session recording or portions of it. It's happened sometimes. It doesn't happen a lot. They could invalidate an action that was taken illegally during an executive session or otherwise. They can issue an injunction like the judge in Douglas County has against the school board there for, at least initially, deciding that these serial meetings to fire the superintendent were against the law. So that we've had an injunction in that case. And the other thing that we have both in the open meetings law and in CORA, which is important, is the awarding of attorney's fees if you prevail. That Woodland Park case is a little frustrating because the judge found a way around that for the school board, and that's on appeal now. So one other thing that I want to mention that's not in the open meetings law, but I think it's relevant, is whether you can go into one of these meetings and record it, like we're doing now by video or audio. And it's not a simple, the answer to it is not yes or no. There's not a black or white answer to it. It's a little bit more complicated than that. We don't have any case law in Colorado about this, but there is in some other states. And so we did a blog about this a few years ago when a crew from 9 News tried to record a meeting of the Park County Commission and were kicked out, which seems ridiculous. And it was ridiculous because it's a public meeting. And the issue is, they're in the public space. They should be able to do that. So what courts have found in other states is that a public body can place reasonable restrictions on the recording of meetings. So you can't necessarily be in a place where you're disrupting, your camera is disrupting somebody else. It's also small now, the technology, like what you've got going there, it's pretty easy to not be disruptive, I think. And so what they need to do, if they're going to have restrictions, it's got to be drawn up very narrowly to burden as little speech as possible. And it also has to apply equally to everybody. So, you might run into this situation, but it's something that you can push back on and fight. So, like I said, it's reasonable to say, please do this from the side. You're not disrupting people. You're not in front of them or whatever. You're not blocking their view, things like that. But generally, you should be able to record a meeting. And I hear about this every once in a while where people are blocked or restricted from doing that. Yeah,
How does that compare, or how does the court justify closing court to such things?
that's a very good question. And that's, when I have talked to Steve Zansberg about this very thing, that's what he brings up. He'll say, well, you know, we don't have cameras in the US Supreme Court. And so courts, and it's, you know, when you cameras in the courtroom are really up to each judge and each case. So there's not any kind of universal right to that. And that's, in his mind, a reason why courts haven't just said, you know, blanketly, all public meetings can be recorded however you want. So if you were to challenge this, I mean, some courts have, like I said, around the country have supported this notion that you should be able to do it. We don't have any cases like that in Colorado yet. But it may all ultimately come back to that, because the judges who make these decisions about whether the law was applied correctly or not, they think about their own courtrooms too. And they, you know, and ultimately the US Supreme Court still hasn't gotten there. They've got audio, but not video.
Well, you could do streaming. I mean, I could see that down the line, not just a video, but actual streaming.
Yeah, so it's very interesting with courts, because there may be a bill coming up on that this coming session. And there's lots of sometimes tricky issues with courts, right? But a council meeting, a school board meeting, whatever, there shouldn't be an issue with that. Most of them should be doing it on their own anyway. They should be, in this day and age, streaming their meetings, at least making them available after the fact. It's very inexpensive to put something on YouTube now. I was interviewed by Colorado Public Radio recently, and I don't think she's done the story yet. A lot of school districts are doing this, but the Cherry Creek School Board is not. So she was asking me questions about, I think she's going to be doing a story about the Cherry Creek School Board and why they're not streaming their meetings like everybody else is, or at least in the metro area is doing. And they should be doing it. The technology is there, it's easy. I think it's what people want. And if some of you end up doing Observer Corps, it's important to have that for both the public and reporters to cover meetings now. It's certainly extremely helpful and useful to have that. So before I go on to Cora, any other questions about open meetings?
Well,
Yeah.
I'm just curious, like when you say if three people were having text messages
Yeah.
outside, I mean, where are those records, and if you're gonna request them,
Yeah.
how do you get them? You know, I try to erase everything on my cell phone.
Right.
Where are those
So the
things?
text messages are not always easy to get. They are the custodian. If they're using their private phone to conduct public business, they're the custodian of those records. So, you know,
Well, and their personal stuff would be on there too.
their personal stuff would be on there too. There might be a way to get it even from their provider, but if they don't have it, but they'll probably say, well, I deleted that a long time ago, and you as the requester may just be out of luck in that case. But reporters and other people have requested and gotten text messages on various things, so it can be done.
So I have a question.
Yeah.
So I can't see the Observer Corps or the League suing anybody to get access to records.
Yeah.
Do we have resources, like does your organization, are there other organizations that would help with?
Yeah, that's a good question. We've never actually sued anybody. We will file amicus briefs when something is on appeal, and we did that recently in a case in Gunnison County. We do have resources for news organizations. We have, my board president, this is his practice. But we also have a relationship with the Reporters Committee for Freedom of the Press. They have a lawyer placed in Colorado now. As far as the public, there are lawyers, a handful, like my board president, who do this kind of work. But that is, it's between the person interested in suing and the lawyer. There's not necessarily any kind of fund or anything like that to draw on. So what we try to do at CFOIC is give you the knowledge to know how to fight these things. And then if something gets to the point where, it's just ridiculous and legal action is the recourse, then we try to, figure it out after that. So, yeah.
To qualify for a government meeting, would an advisory board of volunteers to a government office?
Yeah, it specifically says advisory.
Okay.
So it has to be, if it's appointed by the public body, then it is definitely covered by the open meetings law. If the school, and this has come up, if the school superintendent as the administrator appoints an advisory board, then they often claim it's not covered by the open meetings law. So this happened with Denver Public Schools and their committee, their advisory committee on, what do they call it? It's the thing to examine whether schools should be closed or not. I can't remember the name of it, but it's been a big issue in Denver. And they closed those meetings to the public. They met for a year, public was not invited to those meetings, and they claimed that they could get away with it because it wasn't actually the school board that had appointed the advisory board, it was under the superintendent. So there's a way around these things sometimes.
That's a giant loophole.
Yeah, there is a loophole sometimes. It also came up, I wrote about this one, the Gray Wolves reintroduction plan. Those meetings, some of those meetings have been closed to the public for that reason too. Should I get to Cora? Wait, do you have one?
Just a short question. So an advisory board, a city commission, can they go into executive session?
Same rules would apply.
Same.
If it's an advisory board that's appointed by the commission or the school board or the city council, the same rules would apply to the advisory board that apply to the
Okay.
body itself. So it's just what the open meetings law says. So, yeah, I love the questions, this is great.
Yeah, and maybe this is more for Sonia and company, but I'm just curious, with the project that we're talking about, do we anticipate a lot of resistance from the organizations that we're gonna observe? Like, kind of to your point, Pat, like, we're not gonna, to me, the league should be providing a service to journalism as opposed to becoming a policing force of.
So this is just my thought, I wouldn't think you would. I say these things because I've now done this job for 9.5 years and I know what comes up. It doesn't mean that it comes up all the time. These are things to watch out for and to know what your rights are and to know that we are available to help you understand that. And that guide is online for that. It's not to say that, they're sitting there, if you see somebody in a council meeting texting, that you should be suspicious that they're doing something illegal. Maybe they are, but you don't have to presume that. You probably need a little bit more evidence than just watching somebody texting.
I can speak to that. I expect there to be some surprise, but I don't know about resistance. There might be ignorance, Like, we might come away the first time and be like, oh my gosh, they don't even know what, any of this is. But I don't expect a lot of resistance based on back east where, they have a couple thousand people doing this. One of the leads in that organization says that sometimes the groups are flattered. That showed up, It's like,
Yeah,
hey, they're here.
I
Let's
actually-
make sure they get the mic set up how they like it.
I actually would expect more of that.
Well, I think also if we follow the current guidelines of the Observer Corps as it exists now, you say we're coming. You let them know we're coming, and you give them a letter of introduction.
Yeah, and that's, I really would expect more of that, because a lot of people, with these small boards, they're doing this because they think it's important to do it. And the fact that somebody's paying attention to their work, they might really appreciate that. It doesn't mean that they're automatically gonna be trying to hide something.
Yeah, we're not out to play gotcha,
No, you're observing. Your main function is to know what's going on.
Yeah.
That's coming out of those meetings that nobody ever hears about, because people aren't coming to the meetings or aren't watching, and underlying the purpose of all this is what's happened to journalism. So, the fact that there just aren't enough reporters to go to these meetings. I used to be one of those reporters that had to sit through government meetings, and there just aren't enough of them anymore. And so that's a big reason why we're even talking about doing this. Yeah.
But Loveland Council and, there may be some sticky points at, some critical junctures, but.
Yeah,
Well,
yeah.
you probably know that going in.
You think?
Yeah.
Yeah, I mean, you already know that some of them have a little bit of a history, right?
Yes.
They wrote, our city council has been advised by Moses Garcia to daily erase their texts. That they only have to save them if it's already something in litigation.
So that gets to the records retention issue. And we have a relationship with the University of Denver Law School. Law students will do reports for us every once in a while. We had one do something about email records retention a few years ago. Our records retention law in Colorado is very weak. So especially for things like emails and text messages. Everybody has a records retention schedule, and you should look at that sometimes, but it's not the fact that it's an email or a text message that decides whether they should keep it or not. It's like what you said, it's the content of it. If it involves litigation or something else that, according to that records retention schedule, is deemed important, they're supposed to keep it for a certain amount of time. So they may regard their text messages as what they call transitory, that they're not important to keep beyond a certain amount of time. Somebody else may have a different view of that text message. A reporter doing a story about something may request those text messages, and they could be gone. And that reporter may have thought they were important to keep, even though the council member did not. The example that always comes to mind when I talk about this is the Flint, Michigan water crisis. There were officials eventually held accountable for that, in part because there were emails and things that were available to look at, to see what kinds of communications there were, who knew what when. And in Colorado, if we had something like that, I would worry that those wouldn't exist anymore because of our records retention laws. There's going to be a Cora bill this coming session that we're working on with the Press Association, and we're hoping that we get something addressed in there about that. The federal government treats especially emails very differently. a lot of agencies have it so that the higher up you are in an organization, they consider it more likely that your emails will be important and should be kept. So if they do it that way as opposed to the subject matter.
Loveland City Council, certain Loveland City Council members this morning happened to have a meeting about the legislative policy agenda, and that was one of the items that came up that they are vehemently against.
What, oh, the Cora bill?
Yes.
Oh, good, we're already making waves. This is good.
They're going along with the Colorado Municipal League's
Yeah.
position.
Yeah, and we will, you know, we will be working with the municipal league and those groups on this. We're not gonna just go into it, you know, in total adversarial way. We wanna talk it through. We have a good relationship with the municipal league, so we want to, you know, we wanna come up with something that works for both, you know, works for the public and for journalists and for them. So, you had a question?
Oh, yeah, and it might be pretty naive and relate to our purpose in doing this, but, I mean, most of these things I can think about do have minutes of their meetings.
Mhm.
So in terms of like attending and observing, as opposed to reviewing
Yeah.
minutes,
Yeah,
what do we get out of that and how should we use
Yeah.
that? Or
so
how do we integrate observing with reviewing minutes?
the first thing I'll say about that is that the open meetings law just says they should take minutes. It doesn't say what the minutes shall be. So everybody does it differently. Some may have really thorough, great minutes, and some may have really bad minutes, you know, that don't tell you hardly anything. What is often really helpful is now, you know, having meetings on YouTube and things like that. And some of them have this wonderful capability that the Open Media Foundation has incorporated. They're the ones that do the legislative floor action, and and the technology allows you to actually go to a part of the agenda, you know, click on that, it takes you to that portion of the meeting, which is really handy. And so hopefully technology will really help with this, but the minutes themselves, the other problem with that is that they may not post their minutes for a month or so. So, yeah, that can be an issue as well. All right, I'm gonna talk a little bit about Cora. And we'll get back into, you know, this will bring up some of those same issues that we've been talking about, because they can be interrelated. So we have two public records laws. The Cora, the Colorado Open Records Act, governs everything except law enforcement records. So that's a separate law, which if we have time, I can cover that a little bit too. But this is really anything with state and local government that's not a criminal justice record. And essentially with Cora, if you're interested in records about something with state and local government, you can pretty much make a presumption that it will be available to you, because the only way they can withhold it from you is that there's got to be something in the law that says that they can withhold it, or they have to withhold it, or something else in state statute that says that. So you always ask. When people ask me questions, one of my jobs, I don't know if I mentioned this, is to run a Freedom of Information hotline. I recently took my 5,000th inquiry, and it's now up to 5,012 or something like that. So that's what I spend a lot of my time doing, is helping people, both people in the public and journalists, and sometimes people in government. And when I get questions that say, is such and such a record available to the public, I usually say, well, have you tried making a request? Because we want, you know, the information that I need is if you're denied, was it a proper denial or not? And so you get that information, you try, and then you get that information and you run that by me. What is a public record? It really can be anything that the government produces. If it's made, maintained, or kept by that entity for their exercise of government function. So these days, it's very often something digital. It's not necessarily a piece of paper anymore, although it could be that. It could be an audio file, it could be a video, an email. Emails are very, very frequently requested public records now, especially by reporters.
Can I ask you, I used to work for USDA and I had to respond to FOIA requests.
Uh-huh.
I work with scientists who were basically, I'm not giving my data to anybody until after I've published.
Mm-hmm.
Because that's how they get evaluated, and they're scientists kind of thing. But this is on a federal level. So
Yeah.
there was a mandate saying that they have 2 years after a study in order to evaluate the data and then publish it before it can be released to the public.
Yeah.
Because we worked on some fairly controversial issues like wolves and prairie dogs. Prairie dogs were like, they look so cute, but they're not. But, kinds of things. But it was really difficult, and also the training involved in trying to get staff people. They're busy, and you've got to keep all your emails about this subject.
Yeah.
Are you crazy? I'm not doing that.
Yeah.
Kind of thing.
Yeah, I mean, the federal FOIA has
This
very
is federal.
specific rules, and the agencies have specific rules like that. And on a state and local level, people in government will complain about that. That I have to spend my time responding to this open records request. I have other things to do. Well, the way we look at it, it's also part of your job.
Yeah, well, and also, it's kind of like the FOIA requests that come in are like, I want everything you've ever done on prairie dogs. Going
Right.
back 120 years.
Yeah.
you know.
So, and I'm gonna get to this,
Okay.
but one way to not, to curb that is by charging.
Yeah.
So there is a cost to obtaining public records. We think that the law needs to be changed, but that's how you deter that. If someone says, I want every email you ever produced, and that's just gonna tie the person up forever, they'll have to pay for that.
That kind of knocks out the public who doesn't have somebody who doesn't have any money
Right.
coming in.
And I'm gonna get into that.
Okay.
So there is, yeah,
Well, I get the Colorado Parks and Wildlife stuff, and I think they have the different approach. They flood you with information, and then you don't know where to find what you need. You can also,
but you can't go to the
deter
wolf
people by
wolf
sending
meetings.
too much.
Right? Yeah, we are all flooded with information now. But that doesn't mean that Parks and Wildlife doesn't get Cora requests, because they asked for and got a bill last session about sensitive species. So they got a law passed last session. I wrote about this on my blog that it makes it harder for them or makes it easier for them to deny a request for data about sensitive species, because they were getting a lot of Cora requests for that. Even though they might put stuff out about that, others wanted the exact locations of the sensitive species. So, somebody's always thinking about how to use these laws, which generally is a good thing, but yes, there are people that also may take it too far. And unlike FOIA, which you can sometimes wait months or years for records, in Cora there is a response time for records that are not readily available. It's supposed to be 3 working days. And if there are extenuating circumstances, which are outlined in the law, they can extend that by another 7 working days. That's another thing that sometimes gets fudged because people don't sue over this issue. So Sometimes people can wait longer for Cora records, but you keep bugging them about it and pointing out what the law says. So cost. So the cost of obtaining public records, which can sometimes be very high, sometimes hundreds or thousands of dollars, is tied to the research and retrieval rate. So that is what the government can charge to not only dig up the records for you and assemble them to give to you, but also to have their attorney review before putting them out there, in case they're, they want to make sure they're not putting out something that they can't put out there or they don't have to put out there. And so they could charge after the first hour up to $33.58 an hour. So the hourly rate is capped, the number of hours is not capped. So you could make a request for emails or something like that, and they could say, well, that's going to take us 14 hours to do this, and it's going to cost you, 14 times or 13 times 33.58, and the price starts to go up. So then you have to decide how to maybe narrow your request. The thing you don't know is if it actually is going to take 14 hours. There's not a lot of, you have to take them at their word. I, having done this job for a long time, have heard about a lot of cases where people are trying to get public records and it's going to cost them a lot of money, and it's, they're the public's records. So we're trying to do something, and this Cora bill hopefully will address that. If we don't address it, this hourly rate is going to go up in 2024 with inflation. And you might have heard that something's been going on with inflation. Yeah, I actually asked, over the summer, a legislative council sets this rate based on CPI. And the director of legislative council, which is the research arm of the legislature, she was very nice. She did a calculation for me about what it would be if they had to calculate the rate now, and it would be over $40 an hour. So it might be, if they don't do anything about this, they don't change the law in 2024, that 33.58 could be 40-something. It's probably going to be 40-something. Yeah.
I thought there was a section in law that said if the information you were seeking was to benefit the public.
That would be great.
They didn't have to. Well, I put in a request for information once from the Department of Regulatory Agencies, and they gave me back this outrageous amount, $20,000.
Oh, nice.
And I said, no, you shouldn't charge me at all because it's in the public interest. They sent it to their legal department and offered to do it for free.
Good for you. That's wonderful. They don't have to do that.
Oh, they
There is
don't?
nothing in the law that says
Oh,
that.
okay.
We would like that to be in the law. Yes. So I have not seen the bill draft yet of what Senator Hansen, who is our sponsor, is going to agree to put in the bill. But I'm hoping there'll be something along those lines. The issue becomes, well, what about political organizations? They make tons of Cora requests. Are they the public, or should they be treated differently? What about law firms? What about, so it's tricky. It's tricky. If it's the League of Women Voters, if it's a news organization, I don't think they should have to spend all this money to get public records. Yeah.
In this, the 21st century, of digital, why can't they make some and say everybody's got to get their records digitally? I was surprised
because
that the water courts aren't digital.
Well, they should be digital.
Well, they weren't totally
Meaning-
when I was
meaning
searching them.
they're using paper?
Within the last, maybe last year.
When you
It was hard to find anything.
When you say digital, do you mean just put the records online, or do you mean?
Available, don't get hung hung up on the water court part of it, but I
Right.
found it difficult to find.
So,
But can they make a law saying everybody by the certain, a year, put all your records digitally
You're
and
talk-
searchable, and then that
oh,
would
you're,
be a problem?
when you say digital, you mean online?
Yeah, well, available online,
Yeah, okay, so that's different than having them be digital.
I'm saying get it away
Yeah.
from the print on all of that and copying all
Right.
that sort of thing.
If there,
Get 'em
so
online.
there are way too many records to put everything online, and there's way too many records that they would have to go through before they decided to put them online. There are some records online, and we encourage that, but, in fact, so Commissioner Kafalis, who, when he was Senator Kafalis, was our champion in the legislature. He helped us with some bills, and while he was still in the legislature, we discussed with him and what's called an open data bill. And it never got introduced because of these sticky issues, making state government put everything online. There's a lot of work that goes into that, and there's a lot of pushback against something like that. It would cost a lot to do that. But everything is, just about everything is digital
Is it?
nowadays.
Digital, well, that's a good start.
Well, they're not using,
Free open
they're not
records is
creating,
still
they're not
online.
creating records on a typewriter anymore, so,
Yeah.
yeah. So, here's just an example of, how are we doing on time?
10 minutes.
10 minutes, okay. An example of a news organization wanting to get records about how the Polis administration responded to COVID initially, had to pay $1,290 for records. News organizations can't afford that, but they might do it every once in a while. Real quick, there are sections of Cora, one section about records that governments have the discretion to withhold, and then there's another section about records that they must withhold. And then elsewhere, scattered throughout the statutes, are provisions that address this stuff. And they're all over the place, and there's no way to just kind of list them. But some of the things that they have discretion to withhold are you provide your email to government, they can withhold that. CSU is doing a research project, they can withhold information about that type of thing. Details of security procedures. This is really important. This was put into the law after 9/11. Makes sense. You probably heard recently that I think it's in North Carolina, some power stations have been attacked. It's that kind of thing that it was made to address, the details of things like that. But of course it gets abused. So here's a story that the Boulder Daily Camera did a few years ago on Ralphie the buffalo. And the reporter, who now works for the Denver Post, asked for some records about what happens to Ralphie when it's not football season. And CU redacted these records, citing this post 9/11 security provision to redact the whereabouts of Ralphie the buffalo. I guess because, CSU students will kidnap Ralphie or something. So it can get ridiculous. It's not what that provision was intended for. And then there are things in Cora that they have to deny. Information about public school students, which are also protected by a federal statute. The books you check out from the library here. So we have a really interesting issue, which I've written about a few times, and we just did an amicus brief on this because it's in the Court of Appeals. The library in Crested Butte, people, and this may have happened here, people will submit forms to either want to get a book banned or reclassified in the library because they don't like the book. This went to court in Crested Butte in Gunnison County, and the judge ruled that the people's names, contact information can be redacted, has to be redacted, as part of the library user law, which protects the information about the books you check out. But these are people who want to change the policy of the library district to ban books. We think that's a totally different thing. And so that's an interesting issue in the Court of Appeals now about whether people who want to ban books can remain anonymous. You don't even know where they live. I mean, they could be out of state. It makes total sense that the books that you're checking out from the library, that's your business. Same as if you went to buy books at a bookstore. So that's something in the law that's a mandatory denial. There's also a mandatory denial for the personnel files of people who work for government, except that's you have to know a little bit more about that. It's very narrowly construed by the courts to mean their personal information, their home address, their home phone number, not their job
Not their
performance.
salary.
Not their salary, not if they've been disciplined. So this is probably the thing we fight the most. You know, a reporter asked for, this just came up recently with the director of the Office of Emergency Management for Colorado. He was suspended a couple times, and a reporter for the Denver Post wanted those records. Why was he suspended? What was the deal with all that? They originally denied him those records. He called me. I got a lawyer involved who convinced the state agency to give up these records. And it was a pretty important story to get out there about the leader of a state agency who was accused of, I think, harassment and stuff. So you have to fight that sometimes. I don't have much time left. Emails. Emails are and text messages, very frequently requested public record. It's the content of the email that determines whether it's a public record or not. It has to do with public business. Doesn't matter whether it's on your personal account or not if you're a public official. So those Loveland city council members who are texting, if they're texting about public business, council business on their Verizon phone that they paid for, those text messages would still be public record that you could hopefully get access to if you tried, because they concern public business. The text messages that have to do with anything personal, no. We have some case law about this. Several years ago, the Arapahoe County clerk was having an affair with his deputy. The Denver Post and the Rocky Mountain News heard about this. Apparently they wanted the messages between them. And this went all the way to the Colorado Supreme Court, which held that the messages about their personal business and their affair were not public records, but if those messages also talked about county business, the budget, the boring stuff, those were. Settlement agreements are public records. This is this is another case this is a settlement agreement with another state director. That's public record. Help the Denver Post get that. Autopsy records are public records. They're not criminal justice records. We recently had to fight to get the amended autopsy report on Elijah McClain, and had to go to court to get that, even though Cora says they're public records. This is something we helped get passed in the law. I used to do data journalism at the Denver Post. This was really important to me. Digital public records, if records are kept in sortable formats, like a spreadsheet, they're available to you in that format, that type of thing. A searchable PDF can't be provided to you as a static PDF. So that's important sometimes when you want to do some analysis on public records. Challenging a denial of access. Once again, there's no administrative way to appeal denials. You have to go to court. There's a process in the law for that. You have to provide a notice of intent to sue. There has to be a discussion before you actually file a lawsuit, see if you can resolve it. If you prevail, you get court costs and attorney's fees, so that's important. I have a lot of advice on our website about writing the Cora letter. The main thing, if you're gonna request records under Cora, always ask about the cost. Is this gonna cost me anything? And as you found out, that $20,000, yikes. And then really the most important thing is ask for an explanation if you're gonna deny any or all of the request. An explanation that cites the statute. They often will just include that, but if you ask for it in your request letter, you know you're gonna get it, you're entitled to it under the law. It's really important information, because then if you get some denial and you're like, this doesn't sound right to me, you can run it by Jeff, see what he thinks. We don't really have time to get into criminal justice records, probably. They operate a little bit differently. I don't know that you guys will ever be requesting that like reporters do. We've made a couple of really good strides in Colorado with criminal justice records, with police internal affairs records. We helped get those open a couple of years ago, 3 years ago. And now we also have a new law on body cam footage, which is really important to hold police accountable. So that's my thing.
Oh, that's wonderful.
So, can I, it's more of a statement than a question, but I think there's this feeling that there's always gonna be people pushing against what we're trying to do, and I think that's where you get involved a lot of times, but I wonder if it's worth saying that most of the time they'll be delighted to see us.
I think, and I tried to say that before, I think that's the
Yeah.
case. I really think that's the case. So my role is twofold, I think. My role is know your rights. Just, that guide will help answer a lot of questions, just to know something about what these laws say. And if you do run into a situation where you're closed out for some reason, know we're available and you can ask. So I think you will, in most cases, be welcome. I think most people who do those jobs, do it for the right reasons.
Thanks.
Will this presentation be available on our website?
Working
on it, not immediately.
Yeah,
We're seeing what we
yeah.
get. We're kind of.
But please, if you want to stay in touch, I have a newsletter you can sign up for. We think it's important to have sort of an ongoing conversation about these issues. I never have a problem filling up a newsletter with issues every 3 to 4 weeks. There's always stuff either I write about or that news organizations write about. There's always stuff going on. And so sign up for that if you'd like. And use the website, use the Sunshine Laws Guide, and feel free to contact me if you need to. And if you're on social media, we're on there. So we have a Facebook page, we have Twitter. I don't know what's gonna happen with Twitter, but we're on Twitter, COFOIC. We're on Facebook, we're on LinkedIn. I'm trying out a couple new things because of what's going on with Twitter.
Thank you.
Thank you so much.
Thanks.
There's a notepad somewhere for you
It's
all.
over here on the table.
Oh, great. Please